Imagine this. Your father passed away after a long illness. You're still grieving. You haven't even finished the paperwork at the hospital. And then a letter arrives. It's from a debt collection agency. They want $18,000. Credit card debt. Your father's name is on it. And then another letter. A medical bill. $43,000. Then a call. You need to take care of this to protect the estate. You start to panic. Are you responsible? Can they come to your home? Your savings? Here's the truth. Most families in this situation have no idea what their rights actually are. And debt collectors know that. So today, we're going to change that. Let's start with the single most important thing you need to understand. When you die, your debt doesn't die with you. But it also doesn't transfer to your family. It transfers to your estate. Your estate is the legal entity that holds everything you owned at the time of your death. Your bank accounts, your home, your car, your investments, your savings, everything. Before a single dollar goes to your children, your spouse, or anyone else, your estate must first settle every outstanding debt you left behind. Think of your estate as a temporary financial container. It absorbs your assets and your liabilities. Your family gets what's left over, if anything is left at all. This process is handled through a legal procedure called probate. Probate is the court-supervised process that settles a deceased person's financial affairs. Here's how it works, step by step. First, an executor is appointed. If you left a will, you name this person yourself. If you didn't leave a will, the court appoints an administrator. The executor's job is to act as the financial manager of your estate after you're gone. With a will, you choose. Without one, the court chooses for you. Step 1. Notify creditors. The executor is legally required to notify everyone you owed money to: credit card companies, banks, and medical providers. Creditors are given a set window, typically a few months, to file a formal claim against the estate. Once that window closes, no new claims can be filed. Step 2. Pay the bills. The executor uses the estate's cash and liquid assets to start paying off what's owed. Every legitimate debt gets settled, one by one. Step 3. Liquidate assets if needed. If there isn't enough cash, the executor may have to sell assets. Your car, your home, everything is on the table until the debts are cleared. Investment accounts, stocks, bonds, all of it. Step 4. Distribute what remains. Only after every valid debt, every legal fee, every tax obligation has been settled, only then do the beneficiaries receive their inheritance. This is why estate planning matters so much. The difference between a well-structured estate and a poorly structured one can mean hundreds of thousands of dollars for your family. Now here's where it gets interesting. What if someone dies with more debt than assets? This is called an insolvent estate, and it's more common than people think. When an estate is insolvent, debts are paid in a specific order of priority dictated by law. It goes something like this. First, funeral expenses and estate administration costs. The executor still needs to be paid. The funeral still needs to happen. Second, taxes. The government always gets paid first. Third, secured debts. A mortgage, a car loan. These are debts tied to a physical asset that take priority. Fourth, unsecured debts. Credit cards, personal loans, and medical bills. Once the estate's assets are completely depleted, the remaining unsecured debt is typically written off. The lenders take the loss. Under the Fair Debt Collection Practices Act, debt collectors cannot legally force surviving family members to pay these remaining debts out of their own pockets. That collector calling your house, pressuring you to pay your father's credit card, they may be breaking the law. You have rights. Know them. Now, to be fair, there are situations where family members are legally on the hook, and you need to know exactly what they are. If you co-signed a loan for someone, you are equally responsible for that debt. The lender doesn't care that the person died. You agreed to be liable, and that agreement stands. This is different from being an authorized user. Authorized users did not sign the credit agreement. They do not owe that debt. Period. In community property states, the law treats a married couple's income and debts as jointly owned. In states like California, Texas, Nevada, Washington, and a few others, the law treats marital debt very differently. If your spouse accumulated debt during the marriage, even if your name was never on the account, you may be responsible for it. If you inherit a house with a mortgage, you don't inherit the debt in the traditional sense. But if you want to keep the house, you have to keep paying. If you stop, the bank forecloses. Same with a car. Inherit it, take over the payments, or the lender repossesses it. Now, exception 4, filial responsibility laws. In more than half of U.S. states, laws exist that can require adult children to pay for their deceased parents' unpaid medical or nursing home bills. If the estate cannot cover them, the bill can come to you. These laws are rarely enforced, but they exist, and nursing homes have used them successfully. This is why long-term care planning matters, for your parents and for yourself. Long-term care planning is not optional. It is a financial necessity. Plan now, so your family doesn't pay later. Credit cards and personal loans. These are unsecured debts, meaning no assets back them. The estate pays them if it can. If not, they're written off. Family members who aren't joint holders owe nothing. Federal student loans. One of the most borrower-friendly rules in American debt law. Federal student loans are completely discharged upon death. The executor simply submits proof of death, and the balance is forgiven entirely. Private student loans are different. Private lenders operate under their own contracts. Some lenders forgive the balance, some don't. Read the fine print. Medical debt. One of the most common debts people die with, and one of the most misunderstood. It's unsecured, but in most states, it is given high priority in the probate. And the amounts can be staggering. It gets paid before credit cards, before personal loans. Mortgage. A secured debt. The home serves as collateral. Heirs who inherit the property must take over payments, or the bank forecloses. If the home is worth more than what's owed, heirs can sell it, pay off the mortgage, and keep the difference. Here's the bottom line. Debt doesn't just disappear when you die, but in most cases, it also doesn't become your family's problem. Your estate handles it. Your family gets what's left. The real danger isn't the debt itself. The real danger is not having a plan. No will, no named beneficiaries, no trust, no life insurance. Those are the things that turn manageable debt into a nightmare for the people you leave behind. The best financial gift you can give your family isn't money. It's clarity. A plan they can follow when you're no longer there to explain it. That's what estate planning is. And if you don't have one yet, that's where to start.